So, Tom, welcome back. Today, we're going to talk about probate again. And this episode, we've talked about it in the past a couple of times in terms of the process of probate and how to settle an estate and what happens. And do I need a will or a trust? We're going to kind of combine all of that today and how to avoid probate, and specifically talking about three strategies in Florida that work. So let's dive right in and just cover really quickly why avoiding probate matters. For someone who's just starting to think about it, maybe give us a quick definition again of what is probate
Mhm.
and why do so many families want to avoid it if they can?
Well, probate very simply is a court process. And I think that's the number one thing people need to understand. It's a court process. And when there's a court process, that means you have to have an attorney. So, as most people know, attorneys are not cheap. So, anytime you're having a court process, it involves an attorney assisting the administration of the estate. And the estate consists of, and this is what probate is, transferring assets from a decedent's name only to the beneficiaries either named in the will, it's a testate probate, or by provided by statute, which is an intestate probate. Either way, it's going through the court process with an attorney through the creditor period, through the publication periods, all those different types of timelines to make sure your assets go to the people that are supposed to inherit the assets. So it sounds like it's not a terrible thing, but the problem is when you're looking at a probate, you're looking at in Florida, a reasonable fee for the attorney is 3% of the estate, and a reasonable fee for your personal representative that assists in the estate is 3%. So basically, you're looking at a 6% fee, just generally speaking. So if you have $1 million estate, you're looking at $60,000, and that's quite substantial in my opinion. So that's why it's so important to avoid probate, in addition to other reasons. But I think cost are the number one things that jump out to me.
So, what is a revocable living trust and why is it such a common avoidance tool for probate?
One is I think it's an easy way to avoid probate by simply transferring assets from your individual name to a trust name. The benefit is a trust really is a disregarded entity. It's a grantor trust during your lifetime, which means you do not file any additional tax returns. You are the trustee of your trust. You control your assets. So you retain a 100% control of your assets during your lifetime as the trustee of your trust. But when you become incapacitated, you name the person that you want to handle your assets. From your incapacity standpoint, you have a successor trustee that avoids guardianships of the property. And then ultimately, when you pass away, you control your assets. You control who the trustee is to administer those assets without having to go to court and without having to go through probate. And you dictate the terms and conditions under which your assets are inherited and who they go to, whether you have a drug addicted child, whether you have a special needs child, whether you have a young child who's incapable of handling money, whether you have a great 40-year-old child who's just a bit of a spendthrift and you can't leave all the money to them. The trust will also allow for a continuation after your death to administer those assets subject to the terms that you set forth.
Okay. And so, what kind of assets should usually be placed into a trust?
That's the $1 million question, funding a trust. I think it depends on whether my client is single or married, whether they're looking for tenancy by the entirety creditor protection during their lifetime. So a lot of my clients that are looking for tenancy by the entirety protection, right now, what I'll do is I'll leave the accounts in their married name so that it passes to the surviving spouse and ultimately put a beneficiary designation on the investment account so that it avoids probate. If you're an individual person and you don't have any of that tenancy by the entirety protection, then a lot of times we put most of the assets into the trust.
What role do beneficiary designations play in avoiding probate?
So it's really, again, when you talk about a simplistic vanilla ice cream, back to my little lady, that great client. She just has one son, Bobby, and she just wants the account to go to Bobby. I can do a ladybird deed and a beneficiary designation. Go to your bank, go to Wells Fargo, go to Merrill Lynch, go to Truist, go to your bank and ask for a POD, payable on death form, or if it's a credit union, a TOD, a transfer on death form. So that basically says, hey, this is my money during my lifetime. I control it, only I control it. But when I die, all my child has to do is go into the bank, give them a death certificate, and the bank will transfer the money free of probate, free of a trust administration, free of creditors currently in Florida directly to my child. So it's a really, really convenient, easy way to transfer assets. But again, if you have a disabled child, if you have a spendthrift child, you have a child with creditor issues, if you're looking for spousal protection and credit protection after your death for your son or for your daughter, then a beneficiary designation is not great. Again, ownership is a different thing. I never really like having joint ownership with children. For example, if I put my son Hunter on my account and he gets in a car crash, then his creditors can take my money. So I'm not big on joint ownership with children. Typically, with ownership, I refer more to spouses where it's tenancy by the entirety with between husband and wife, where it automatically passes to the spouse on the first to die if that's what they choose. But again, that can be a problem. Sometimes my clients come in and they have two children. They say, no, I'm going to give it all to Bobby when I die, and Bobby's going to split it up. Well, what happens if Bobby dies? What happens if Bobby gets sued? All those things. Is he going to take care of his sister afterwards? So again, you have to be very careful with joint ownership. I prefer beneficiary designations with single people, especially.
Okay, so give us a list of the types of accounts or assets that can usually pass outside of probate this way, so everybody's clear. We talked about
Sure.
Ladybird deed being real estate,
Mhm.
beneficiary and ownership
Yeah. So,
designation. What
yep,
accounts?
on bank savings, checkings, accounts like that. Typically, you're going to have at a bank, you're going to have something called a payable on death, as we previously mentioned. With a credit union, you're going to have a transfer on death with your checking accounts. With your investment accounts at Merrill Lynch or at Smith Barney or wherever you invest your money, typically you can have beneficiary designations. Most of the time, they're called transfer on death with investment accounts. With your IRAs, your 401ks, they refer to them as beneficiary designations. And you typically will have a primary and a contingent.
So let's get into maybe some indicators or mistakes that you see all the time that um, a client or a person's current estate plan may not avoid probate the way they think it will. Or what are some of the common mistakes you see being made by Florida residents in this process, by themselves or if they're DIYing or by other attorneys?
Well, the first one's pretty common. So when anytime they have a revocable trust-based plan, they do not properly fund their trust, transfer the assets into the trust, or they do not put proper beneficiary designations on their assets. So I think that's probably the biggest issue with what I see with trusts. With regards to beneficiary designations, I think people fail to see that um, sometimes children don't get along. For example, I have when I die in November, my estate still has all my final income taxes to pay. Okay. So the benefit of having a probate or a trust administration is you have a fiduciary who's in charge of your assets to file your final tax returns. If I just have all my accounts as beneficiary designations and it's myself and my brother Ken, and we hate each other, we don't get along, and all of a sudden I call my brother Ken and say, hey, half that money that went directly to you on that beneficiary designation, I need $10,000 back to pay your share of the taxes. And he says, no, I'm not going to do it. I say, wait, we have to pay mom's taxes. She's passed away. These taxes are due. Mom's funeral bill was due. All the little bills and expenses that get taken care of by a fiduciary. When you have direct beneficiary designations, it goes directly to the beneficiary designations. Yes, you avoided probate, but if you have kids who don't play nice together, that's an additional burden you just created on your children. So you got to be very careful with that. So you have to know the relationship between your children. You know,
Mm.
for example, do you want to be, my son lives in, we're becoming I used to say we're becoming very national where, just because you're raised in Florida does not mean you live in Florida. We're becoming very international. I have many clients whose children live in Germany and Holland and Japan and all over the world. If I put my son as a beneficiary designation, the bank's going to want him to come back to collect his money. It's kind of a problem if you're in Germany. So again, you avoided probate, but did you solve the problem the right way? So you have to be careful sometimes with those beneficiary designations. Um, again, if I have creditor issues, yeah, I avoid probate with a trust, but trusts have payback provisions to creditors. I might have been better off just using a beneficiary designation so that it goes directly to my son and I don't have to pay back Visa that I owe $75,000 to. So, again, there's all different types of considerations that you have to take into account because they dynamically change everything all the time.